The Court of Appeal is the highest level of court in Manitoba. This court hears appeals from the Provincial Court, the Court of Queen's Bench, and also from many administrative tribunals. The Court of Appeal sits only in Winnipeg, but hears appeals of cases that originated in communities throughout the province. The Court of Appeal is known as an error-correcting court. Unlike the trial courts, this court does not rehear evidence. Rather, it reviews the decision of other courts and, if necessary, corrects any errors that might have been made. You do not have an automatic right to appeal in all cases. Sometimes you must apply to a court of appeal for permission to file an appeal. The rules for when you can file an appeal are very strict. Many appeals must be filed within 30 days of the decision. However, this rule does not always apply. It is very important to check the appropriate statute or act that applies to your case. The party who files the appeal is called the appellant. The other party is called the respondent. Generally, the appeal process begins when the appellant files a notice of appeal. Factums, appeal books, and case books are other documents needed before an appeal hearing is scheduled. Civil rules, criminal rules, and practice directives set out the requirements and timeframes for the documents that must be filed. The large raised desk at the front of the room is where the judges sit. For most appeals, a panel of 3 judges hears the appeal. In very exceptional situations, the Chief Justice may determine that a panel of 5 judges will hear the appeal. Court of Appeal judges wear black silk robes and vests with white tab shirts. They are addressed in court as "My Lord" and "My Lady." The 4 large tables are for the lawyers. At the hearing, the lawyers will make arguments from the podium at their table. These arguments are about the law and how it is to be applied to the facts of the case. There are no witnesses or juries in the Court of Appeal. Sometimes the judges will give their decision orally at the end of the hearing. Other times they may reserve their decision. This means that they will take some additional time to think about the arguments and notify the parties when the written decision is ready. Most decisions are unanimous, but it sometimes happens that a judge will disagree. In this case, the majority view prevails. The Court of Appeal can dismiss the appeal, allow the appeal and order a new trial, or allow the appeal and change the order of the lower court or tribunal. Court proceedings can be a confusing and intimidating process. If you are involved in a case before the court, you are strongly encouraged to have a lawyer represent your legal interests.